if once that particular knowledge comes into the realm of the society in the public, then they can invent further, they can create further. So, that idea is already there, that already is in the public domain, everybody knows, and now they can progress further with it. So, this is how the society progresses. You see, aeroplanes are being made. Now, if I, and everybody knows basic technology, that how it is, how it operates. If anybody has to do what is the present state of art, because it is known to everybody, it has to progress further, it has to work over and above it. Then it will be invention, then it will be entitled to protection, because after all, what is a patent? Patent has to be a new invention, non-obvious and industrially applicable. So, these are the three things which must be there. So, this is what the knowledge is already there. Now, you have to work, invent around and invent beyond, not what is already there. So, this is what author has a right over his creation, economic and moral rights, and the society has a right over that particular creation to know what it is. So, it is in the author or the creator or the inventor divulge, disclose, and in return society protects. For a limited period of time, certain rights are being granted. Second, to promote creativity and dissemination and application of these results and encourage fair trading, which would contribute to economic and social development. It is quite obvious that it will be the person who has done something must be rewarded. Society must know what it is, then it further developed. So, it is a two-way sword. This is that both the parties must benefit. It is a different thing that now the interpretation or the protection of the IP is so wide and so absolute, that where the holder is getting all the benefits and the society is not being benefited that much. That is a different thing, because that I will be telling you later in my this particular presentation. The aim is to create a balance between the interest of the holder of the right by rewarding him and help in the scientific, cultural and economic enrichment of the society. That is the main aim. And next is stated objective of IP law is to promote progress in the society of both parties. I mean, you as I as an individual, because I am the part of the society ultimately, and I will create something new. I will promote progress. My individual progress will be there, society's progress will be there. Of course, except for trademarks, this I have left, later on we will discuss. Characteristics IP, legal right, as I already told you. They are not the common law rights, they are not the inherent rights. These are the statutory, they are legal rights, all IPs. They are limited in time. You see, they are limited in time. I mean, like 20 years for the patent, 50 years plus the lifetime for the copyright. In our country, 60 years plus lifetime, right? For phonographs and performers' rights, that is 50 years, not the lifetime and all those things. And then you see, except for, you see, like in the case of geographical indications, it's a different story, or like trademarks, 10 years. But you have to get it renewed, so which can become infinite, that is also there, but renewal is there. Renewal is there also in the case of patents. If you do not renew every year, after third year, then you are bound to lose your right, the patent as well. So, but it is limited in time, somehow or the other they are limited. So, this is what the main you see the hurdle, I mean one of the main hurdles against the protection of traditional knowledge is that you see it is infinite in time. I mean, how there is no time limit as an IP, because what we talk about the protection of TK, we talk in terms of intellectual property, but TK otherwise we know it is a holistic concept, because it involves so many things. It is territorial in application. There is nothing like international right. Territorial means if you get a patent here, it is not automatically you can enforce it in Nepal, or you can enforce in Bangladesh, or you can enforce it in France or UK or whatever it is. You have to get a fresh patent over there. You have to file an application, a fresh is there. That is a different thing, that there is a international filing also, that is a PCT, Patent Cooperation Treaty is there, where you can in one go you can target 10 countries. But each country, that is also not there, that the International Searching Authority has given you the report and you are entitled to you see get the patent automatically in all the countries. No, every country, every patent office in each country will have to look into that particular application afresh and will grant the patent. So, it is territorial. Suppose I have a patent in India and I have not protected, suppose Bangladesh. So, if suppose somebody infringe my patent over there, I do not have any remedy, because I do not have the patent over there to enforce it on that particular invention. So, it is a territorial in application, and then rights do not exist on physical object resulting from the idea, but instead on the intellectual creation as such. And then rights granted are essentially negative, whether you use it or not, do not use it, but others cannot use it without your permission. That is how it is. These are negative rights. Now, what is the significance of IP? So, in knowledge based economy, IP is economic great importance due to its economic significance. It is itself in itself is a value, because you see right now every big company, they have the IP portfolio. So, whenever there is acquisition or mergers in the company, the IP portfolio also becomes very important. And there is in certain countries like developed countries, it is scrutinization also, that the countries the company is holding such a big portfolio of IP, they can mortgage it with the bank or financial institutions, get the money from it. So, all these things, they are there. So, helps in enhancing and cultivating creative potential of the society, that I have already talked to you. Second, allows creators and innovators to establish and penetrate new markets without minimum risk. You see right now you might have heard every now and then you are reading about the free trade agreement between France and India being negotiated for the last 7 years or so, 8 years now they are running. So, they are because you see they want to invest in India, European countries, then they say that the IP system is very weak, particularly enforcement they are talking about. They are concerned about the enforcement. So, if they say, I mean our IP standards or norms, they are entirely in accordance with the international obligations what we have under different treaties, but the enforcement they are saying that it is very slackening, it is very weak. So, point is that foreign investor looks into the IP scenario also. I for one, I will say that you see investment is not entirely based on you see the IP scenario in a particular country, because there are number of factors, political atmosphere, labor laws, you see exchange difficulties and all those things, they are there. So, but IP these days it is also becoming a one of the important factors for the foreign investor to invest in a particular country. So, this can, in other words, IP can attract the foreign investment and helps to amortize the investments made in the research, you see, because as you know that you people are in the agriculture and it takes years to really develop a new variety, to see that when it is now commercial, it can be commercialized, because sometimes you just develop, you have a new variety, but development takes for few more years. So, you can see how much efforts, how much money it goes, and this is the plant variety, but look into other areas of the like pharmas, millions of dollars in research they go, and then clinical trials and all those things they happen, and subsequently you see it is not so many compounds they come out every year, but at the end of the day suppose 1500 says in general on an average they are being produced every year, and out of that 2 or 3 they can see the light of being patented. That is how it. And it is the argument that and it is also to great extent true also, they spend lot of money out of on it. And then further you can see the clinical trials, they are there, and time consuming and resource consuming both. So, because if under the patent, if the product is under a patent, you have the sure you can have set your own price, which means you can recoup the money which you have spent on R&D. And then you see encourages R&D activity in the country, and on the flip side IPRs block competition. There is a lot of these days discussion going on IP and competition and all those things. Competition Commission is also looking into the standard essential patents and all those things. Ericsson's case you might have looked into, might have seen in the newspapers, that is a news also many of the times. So, these are the things which Competition Commission is looking into, though directly Competition Commission by virtue of section 3 and 4 and 5 particularly, that the IP is not within the purview of the Competition Commission. But if it leads to monopoly of the market, then section 3 and 4 they come into play, dominant position and all those things. Historical perspective, that is the actual topic which this was just the background I was giving, what is IP. Now, when we talk about the IP was never as a word being used. I mean, if you look into the history, you will find that it was a long time back in the 19th century, it was the industrial property and intellectual property, the copyright. These were the two things. The first time intellectual property, it is a generic term which is used for many kinds of different subject matter of the intellectual property which is being used. Under the umbrella of IP, all types of these all types of these subject matters they fall, that is the patents, copyright, the trademarks, designs, utility models, competition, the anti-competitive practices, the plant variety and many other things. They are the subject matter of the IP. They under the umbrella, they are all being covered. So, in the regular use it came into force only in 20th century. Earlier it was industrial property and copyright, that is how it was. So, what was not copyright, that was generally it was the industrial property, that is as trademarks, the patents, utility models and industrial designs. These were the major aspects which were being talked about. Subsequently, the ambit has widened. Now, the first time its use was in 1867 in Germany, and then as I said, in the 20th century it became more common, that is when 1893 the Paris and Bern conventions, their secretariats were merged and there was one single United International Burex for the Protection of Intellectual Property that was being created, which is generally known as BIRP, that was being created. Now, it is being overtaken by the World Intellectual Property Organization, WIPO, in 1967. Now, the WIPO became a specialized agency of the United Nations in 1974, and WIPO currently administers 26 intellectual property conventions or treaties on different subject matters, different areas of intellectual property, including the WIPO treaty itself, because World Intellectual Property Organization is also a creation of a treaty. Now, the growth, when we talk about the IP in the historical perspective, we have to look into the growth in two phases. First is territorial, and then we come come to the international period. Now, what is a territorial phase? Now, the territorial phase which we talk about, that is all these different subject matters like the trademark, like the copyright, like the patent, they originated in different countries at different times. but mainly in the 19th century. The major progress was in 19th century. That is how it is. Now, there was one common element in all these, that they started as a privileges from the king or the emperor of the country to the inventors or to the creators, that is those who are authors were never being earlier being protected, actually the printers were being protected to start with. So, you see the one common granted as royal privileges by way of letters patents to favored inventors. So, those who are the favored inventors, they were being given the these privileges. You see like the royal charters in the form of royal charters, letters clause and letters patent. These were the different names which were being given. But since these were to the favored creators or inventors, there was a lot of opposition or some dissatisfaction in the public, and also the judiciary was very critical. With the result that many countries have started making the laws in this particular respect. And first major act as we come across, that was in United Kingdom. During the Elizabeth era, it was being blamed that it was very much misused, that these letter patents and all those things. And subsequently in 1623, that is the statute of monopolies. You see in each of our patents, that is statute of monopolies in 1623 on patents was being enacted. This was the first which was being enacted, and actually this is the beginning. Many they say this is the beginning of the patent law, the enacted law, and this was, you see, the first, but subsequently US enacted, United States enacted the first law on patents 1790, France enacted in 1791. So, these were the major European countries, there were others, and then subsequently in the case of copyright, the copyright was also, you see, it was sort of a bilateral patent, and it was a privileges granted to, particularly in England, it was granted to the printers. They were considered to be the owners, not the authors, owners. So, they were enjoying the monopoly rights. These letters patent were granted them the monopoly rights. They have to get registered under the there was first 1662 act, the registration of license books aimed at protecting printers against piracy. But the statute of Anne 1709, it was actually the origin of the copyright, where the author was granted the copyright. Author was now the owner of the copyright. Earlier, you see, you had to assign your copyright, you have to license your copyright, but you see here it was the author was considered to be the owner and the author. Earlier it was the owner who had the rights only. Now, the patent law spread throughout the Europe in the first half of the 19th century. Different laws were being made, and these patent laws were not elaborate, they were not very elaborate, just like these days we are seeing, and they were simply recognizing the rights of the inventor, not very elaborate. So, how will they be operating and all those things, they were not there. I mean, they were just talking about if somebody does, I mean, it was not also being specified invention has to be new, not obvious, industry applicable, all these things were not there. Invention, what was a definition? Definition of invention is still not there. If you look into the TRIPS agreement, invention is not being defined. We have in the patent laws, subsequently they have started giving the shape, and you see like in the case of TRIPS agreement, they say invention has to be new, non-obvious and industrial applicable, useful. Now, but what is inventive step, non-obviousness not being defined, you see. So, what is the new, in what context you are you see evaluating a newness of the invention, these things were not being talked about at all. So, this is what, so outside Europe, because these most of the European countries, they were colonial powers. in the 19th century. And outside Europe spread in the colonies closely following the footsteps of the colonial powers in the colonies. If you look into, I will be talking about the Indian context, and look into our whole IP law has its roots in the British acts. All our laws except those which have we enacted in 1999 after the TRIPS agreement, new acts which we have, like the geographical indication, like the plant variety or the biodiversity, all these we have enacted, and they do not have any roots, we have our independent, but otherwise 1970 act, we have made changes, 1957 Copyright Act, we have made certain changes, but they have their roots in the British laws. Now, the designs and trademarks, they are very contemporary, and you see have been subject of more recent statutory protection. Now, the initial period of the intellectual properties growth was dominated by the principle of territoriality, that each country, I mean, they will only guard their own, whatever they have awarded, whatever they have granted, that will be only protected. But you see other countries, if you have any right which has been granted in other countries, that will not be recognized. That is still not being recognized except for the copyright, which I will be talking to you, except for the copyright. All other rights, they are still the territorial. And in the case of, if you look into the performers' rights or the you see the other phonograph and all those things, they are also part, and because they are the neighboring rights of the copyright. So, they are part and parcel of the copyright, and they are being granted, I mean, reciprocity is sort of there, that is union type of approach is there. Principle that is a product of intimate connections to be found between sovereignty, property rights and territory. This principle of territoriality, it has a close connection between the sovereignty, that sovereign will be granting property rights and the territory, in the territory, that is it will be extended. If you do not, if you think that you are not able to follow, kindly do ask the question. Yeah. Now, this is the international phase. After this, you see, as I said, in 1893, the Berne Convention, Paris Convention, they merged. I mean, the Secretariat merged, not the conventions, they merged, I am sorry. Though you see the thereafter, there was a very fast growth. There were a number of other treaties, they were also being concluded. Now, here we come around, you see the started with bilateral, first it was a bilateral agreements between the countries, not there is a multilateral, bilateral approach, sort of a reciprocity, you protect the rights which I have granted and I will protect the rights which you have granted to your nationals. So, this was the approach, but there was approach was also that to the extent which we protect. It is not that in your country the copyright you are granting for 100 years and we are granting for 20 years, that you, since you are coming from that country, you will get 100 years protection. No, there we will protect your work, but up to that 20 years. So, this was there. Now, then the followed by multilateral era of cooperation through two landmark treaties. These are still the leading treaties, that is the Paris Convention and the Berne Convention. Paris Convention and the Berne Convention, these are the two treaties. Now, Paris Convention was concluded, that was on industrial property, you can see that industrial property 1883, and since its adoption in 1883 it has been revised 7 times. Last revision was in 1979. And the Berne Convention for the Protection of Literary and Artistic Works 1886, since revised 8 times, last revised in 1979. By this time you can see the colonies, most of the colonies they were free, most of the colonies, and they were parties because it was all the revisions were taking place under the auspices of the WIPO. All the countries of the United Nations, they were participating, and the developing countries, they have their own agenda. They wanted that their demands should be met, and particularly like India was saying that in the revision of the Paris Convention, transfer of technology should be taken care of. There should be, if we are granting the patent, there should be a complete transfer of technology to that particular country. Because the patents, they deal with technology, you know that. Patents is technology. And you see, it is that by the end of the patent period, technology becomes obsolete. So, it is of no use, and sometimes even if obsolete, the localization, adaptation in the local to the local condition, that also requires some sort of a technology orientation, some sort of a training. So, the developed countries, particularly US, was not ready for that. They have said that it is a free riding. What we are doing, you want to have free riding. So, with the result 1979 did not lead to any result, and which we see as ultimately we have to end up with a TRIPS agreement, that we will see later on. Now, you see, then the Berne Convention, again translation other, there is a actually there was an Annexure 18 which was being added in 1948 for the translation rights to be granted to the countries concerned, those who are the members. So, like India, where the local language, I mean of course, those who are little high educated, they know the English, but most of the people, even those who are educated, they do not have the claim or the expertise over English. So, local languages always the vernacular languages, they are preferred for the spread of the knowledge. So, this was the actually the issue in that particular case also. Now, the 20th century saw the proliferation of international IP regime in the form of many other agreements. If you look into that, we have the this Madrid agreement on the trademarks, 1891. Then we have the performance that the like the 1961 Rome Convention. We have the plant variety protection, the UPOV Convention. UPOV Convention we have, then we have the Patent Cooperation Treaty, then we have Semiconductor Treaty, then subsequently we have the you see the other like the WPPT and WCT, WIPO Copyright Treaty and WIPO Performance and Phonograms Treaty. So, there are still, I mean, many other treaties they are coming out. More recent is on the disabled persons, that was a part of the copyright, but you see it is a separate treaty now, which was being concluded in 2013. So, what I mean to say that if you look into the work plan or agenda of the WIPO, they are continuously working. They are part of the TRIPS agreement, all the substantive provisions. And if you look into the TRIPS does not give you, they are dependent on these particular treaties. They broaden the scope of those rights under the TRIPS, but they do not go into the TRIPS does not go into the details. You will find that these other things they have been defined, and rights, all those they are there under like you see the this is a patents is there, trademarks is there, geographical indications are they are there, that was also being talked about under the industrial property, that is Paris Convention, and Copyright Convention, Berne Convention is also there, Performance Rome Convention is there. So, they give for certain more meaning or more I mean which were the loopholes which was perceived, I must say that they were there, which were perceived by the developed countries, they have been actually taken care of. That is how it is. Right now, you have free trade agreements, regional agreements. So, they are giving further fillip to the standards of these particular conventions. Now, the FTA further widen the scope of mandatory standards of the IPR. Now, what is what the TRIPS has done? TRIPS was in the agenda of the GATT Uruguay round, 8th round, against the opposition of all the developing countries. It started with all the developing countries. Subsequently, of course, the lead was taken by India and Yugoslavia and Egypt at that particular time. But it was mainly at that particular time, there was all the developing countries in the first instance, they were opposed. But the developed countries, as I told you, they were seeing that there was a lot of piracy going on, counterfeiting is going on, and there is no enforcement under these Paris Convention and the Berne Convention. They were also not happy with the negotiations which are going on in 1979, the last which were when they were being revised, and they saw that there is a lot of difference between the developed and developing countries, and they were not agreeable to the demands of the developing countries. They wanted exact standards, absolute standards of enforcement. They also do not want to leave any privilege or any freedom to the countries to decide the standards of protection. So, 1986 ultimately saw the emergence of the TRIPS agreement as a part of the WTO, World Trade Organization. It is an agreement which is ipso facto binding on all the members. If you are a member of the WTO, you cannot say that you will not become the party to the trade in services, the agreement trade in services, or you will not become the party to the TRIPS agreement. No, it is ipso facto binding. If you look into the TRIPS agreement, there is no provision, it is specifically said no reservation is permitted to any provision of the TRIPS agreement. Is clearly being stated. So, you cannot say that we will become a party to the TRIPS agreement with these reservations, that is, we will agree with the copyright provisions, but we will not agree with the patents provision. No, you cannot say. You cannot say that articles 27 to 31 they are out. We will not be bound by it. You cannot say. Whole agreement will be binding on this party. What was that earlier, the Berne Convention and the Rome Convention, the Paris Convention, they were permissive in nature, as I told you, that they were saying that these rights must be recognized and must be protected. What will be the mode of protection, what will be the scope of protection, how it will be enforced, that was left up to the countries concerned. Here there was no freedom. Term was being fixed and coverage is being fixed, article 27. In all areas on fields of technology, patents will be granted in all fields of technology provided the invention is new, non-obvious, industrial applicable, which means anything, which means that biotechnology. Actually, if you look into bio, when we talk about the bio is a nature, part of the nature, and it cannot be, broadly speaking, it cannot be an invention, it is discovery, and discovery is not invention. But here biotechnology is patentable. Then on the top of it, article 27 para 3b, plant varieties have to be protected, right. So, it did not leave any protection. Term was 20 years, Paris Convention did not say. Here it was for the trademarks, 10 years period was being provided. So, all these things were being no concession to the countries. And on the enforcement part of the TRIPS agreement is longest, starting from article 41 to 61, 21 articles, they are entirely for the enforcement. They are for the enforcement. So, you have to provide the criminal sanctions, you have to provide the civil remedies, you have to provide the border protection, that no the pirated goods or counterfeited goods should enter into the market, the customs authorities should be sensitized and the laws should be made, which we have made in 2007. We have declared a sort of a notification, the Revenue Department. So, this was there. So, there is no permission. I mean, it's not permissive, it is prescriptive. TRIPS regime is prescriptive in nature. That is, Paris and the Berne regime is permissive in nature. That is, all the standards and norms, they are mandatory of the TRIPS. That is how it is. You have no exclusion, no excuse also. Now, IPRs covered under the TRIPS. Under one particular treaty, it has 8 particular rights, they have been protected. You can see the copyright, trademarks, patents, industrial designs, geographical indications, layout designs, undisclosed information, protection of plant varieties. You see, it talk about the undisclosed information. It does not unfair competition. That's the unfair competition is under the Paris Convention. Here it is undisclosed information, that is trade secrets. Yes?
What was that FTA?
Free trade agreements. Free trade agreements. So, all these they are there. So, you have to protect all these. So, you can see that all areas except for the trade secrets, we do not have any law at the moment on the statute book. But you see, we have a limited rights so far as the employer-employee relations are concerned, that is under the Contract Act, section 27. An explanation takes care, but data exclusivity and all those things and which have been submitted to the government for the approval, that is not being protected. Government says it's a drug regulatory act and whatever it is, the official Trade Secrets Act, that will take care, but that is not there because I have worked, I mean with I was a part of the ministry's the expert committee. So, there nothing has come out as yet on this particular point. Plant variety protection, briefly I will be talking. You see, as I already said, mandates, the TRIPS mandates that it must be protected either by patents or by a sui generis system or by combination of both. What is sui generis? You have heard of it? Huh?
It's like of its own mechanism.
Yeah, slide on. That is it. It's entirely of its own. It's not trademark, it is not copyright, because these are the principal you see, it is not the patents, it is on its own, different, unique, you can say. Like you see integrated circuits, semiconductor, I mean they are may be protected under the patents, but it has some overtones of the copyright as well. So, that is how you see they have different separate act altogether. Now, the adoption of IPR as such is a comparatively recent origin. The first act which we come across, that was in 1930 in the United States, that was Plant Patents Act. It was covering only the plants which was asexually promulgated plants to prevent the emergence of grain monopolies. Those plants which were not grown out of seeds. So, they were being protected because they did not want to create the monopolies on the essential grains. So, which were produced out of you see the seeds. Now, European plant breeders, they instead put forward to the plant breeders' rights. And it was in 19th century they started. Little different, the plant variety protection and plant breeders' rights. You see, it is not the variety which you are protecting, it is a breeder which is whose rights are much wider, whose permission and everything you are required. Now, you see so each country in Europe, they were having their own system, but there was no unified system. All the farmers, they were fighting, or the plant breeders, they were fighting for the protection. And subsequently, it led to the adoption way back. It started in 19th century, but it was only in the second half of the 20th century that the UPOV convention was being adopted, and this introduced the PVP, that is plant variety protection, as well as plant breeders' rights. Now, UPO Convention, the full name you can see what is this. Or the International Union for the Protection of New Varieties of Plants. It was adopted in 1961 with 5 countries. It was amended in 1968, then in 1978, and then 1991. And I think right now it has 72 countries parties. 72 countries which are the parties to the UPO Convention. Now, after the 1991 Act, which has come into force in 1998, no state can now become a party. I mean, all these amendments, they are known by these are 1968 Act of the UPO, 1978 Act of the UPO, 1991 Act of the UPO. So, they are known by the name of the Act, not the amendment. So, after the 1991 Act has come into force, no state now can become party to the 1978 or prior to that. 1978 replaced the 1968, and as a matter of fact, there were major amendments which were being made.
But India has applied for 1978 Act.
No, we are not party to the UPO.
No, we are not party. Still now we are not party, but we are applied.
Yeah, we are to a great extent. Our plant variety protection it does. And the flexibilities which were provided are provided in 1991 Act, that also we have used, like in the case of the section Article 14 of the 1991 Act. It does say that the country, as a matter of fact, you see the plant breeder has a right over the all the varieties and allow the use or all these sowing. The farm saving seeds, nobody can plant. If suppose you have bought from the plant breeder certain seeds, in that particular case, you see, you cannot sow it in the next season. You have to buy again. Now, you cannot save from that you see harvest and sow it next time. You cannot do that. It is a breach. But here in 1991 Act, the freedom is being given to the countries that they can allow it. They can allow that the farmer can save the seeds from its harvest to resow.
For its own use only.
For its own use.
Only.
Yeah.
You cannot sell it to the.
No, not for commercial purposes. But otherwise, you see, it was that they were not being allowed. I mean, it is up to the country. That is how it is. And moreover, 78 Act and 1960 Act, if you are protecting the plant varieties under the Plant Variety Act, then you cannot protect it under the Patent Act. You see, double protection was not allowed in the 1968 and 1978 Acts. But in 1991, because the US did not become the party to the UPO Convention for this reason, because it was petty patents and the 1930 Act and all those things, they were there. They were not very agreeable to the granting only the plant variety and not the patents also. So, it was that the parties can provide the patents simultaneously, patents and plant variety protection. So, this was the major. And then you see what was the restriction on reuse of seeds and the use of essentially derived varieties for research. These are actually these new additions were being made here, which were not there in 78 Act. So, this is how that is the UPO Convention. I am not dealing with the UPO Convention in detail, as I know that you are going, maybe your 2 weeks will be spent on those areas. So, I will leave it to at that, because I am not going to explain essentially derived varieties and all those things. So, you also know that what are the essentially derived varieties, more than I know, because I am from the law and you are actually from the science and agriculture background. What is the growth in India? In India, you see, has its roots in the system, as I already told you, in the system established by Britain in India. Actually, whenever the UK was passing any act, we were just after a year or so, we were having the same act in India as well. Actually, they were the copies, practical copy of the British acts. And the British sometime, why we were not becoming a party to the Paris Convention, because one reason was we were saying that the it gives the right to the patent holder as a you see use the country as a captive market. You get the patent, you will not allow others to enter into the market because you are the one. And here also the Britain wanted to sell its own products, all those things which it was producing in Britain. So, they had the patents here, and local industry will not grow. That is how that was the main motive behind it. Patents first introduced in 1956, because 1955 there was the English Act. Protection Inventions Act 1956 replaced by the Patent and Designs Protection Act 1872, it was replaced, and then it was further in between there was small changes, but it was major change came, and that was a major actually, the Patents and Designs Act 1911, and which brought the patent administration also under the control of patents. First time control of patents was being appointed. Then patent term in under the 1911 Act was 14 years for all patents. Actually, there was nothing like process patent or product patent. Patent will be for 14 years. There was no distinction made. Now, the Act was amended in 1950 after when we got the independence. Bakshi Tekchand, who was the retired judge from Lahore High Court, he was the first who headed the committee. On his suggestion, some amendments were being made. Then Iyengar committee was being established. I mean, it was 1953 or so, and report was submitted 57, and then it did not see the light of the day for many years. Again, some select committee was being constituted. It looked into that Iyengar committee report, and ultimately we see the 1970 Act, which is we today have the Act, and it is in force from April 1972, amended since then 3 times. And this was all these amendments were after we became party to the WTO TRIPS agreement. First amendment was in 1997, second was in 2002, and third is 2005. But actually, if you look into the 1970 Act did lot of good to the country. It for the first time, I mean, it introduced product and process patents in all sectors, but the product patent was not available for inventions relating to food, medicines or drugs or substances produced by chemical process. That is there only the process patent was there. And that actually saw the vibrant drug industry in our own country. If you look into the drug industry, which is generics which are being produced in our country, and which India is the major exporter, one of the major exporters in the world, and I think it's about 25% of the world's generic demand is met by India. And the cheapest, it's the cheapest source. Actually, if you look into in 1968 when the select committee was there, and when they were looking into Iyengar committee report, that time it is reported, I mean actually recorded in not only in India, world over, in India the drugs were sold at very high price. I mean actually it was the highest in the world that time. The price of the drugs in India was the highest at that particular time. And then you see that API, the active pharmaceutical ingredients and all these generics, we are the major exporters. And now right now you might have heard that India has deferred the talks on the FTA with the European Union, because you see there are a number of drugs which are being 700 drugs which are listed that they cannot be sold there. So, this was actually the main dispute, but I mean to say that in India's drug, it is not only in Europe, in the United States is going, but it is India is a major supplier for Latin America and for Africa. And even for you see the Asian countries, I mean when there was HIV/AIDS problem, then India was there, and these drugs were being imported by South Africa and by Thailand and by Brazil from India. So, what I mean to say that the 1970 Act, when it made changes by process introducing process patent and excluding the product patent, because under the 1911 Act it was the product patent. In 1950 also it was being kept. It is only in 1970 this major change was being made, where the process patent was introduced and no product patent could be granted in the area of food, medicine, drugs and substances of chemical process, and term of process patent in these inventions was 7 years, and this was 7 years from the date of filing, 5 years from the date of sealing. In all others it was 14 years. Now, the trademark was first enacted in 1940. Prior to that, you see the trademark was registered under the India Registration Act of 1908. And there is a history so far as the after independence, we have the 1958 Act, which replaced the 1948 Act, and now we have 1999 Act, which repealed the 1958 Act totally, and it is in line with the TRIPS agreement. All these changes which are being made, they are in line with the TRIPS agreement. Now, the first copyright law was enacted in 1914, which was based on the 1911 British Copyright Act, but this is not the beginning of the copyright law in India. You see, here was in the at the time of East India Company in the 1847, we had an act which had the you see the life of the author plus 7 years after his death, but in no case the copyright will be more than 42 years. That was the ultimate, that is how it is. But then 1940 Act, it was, as I said, that it was extension, and where we get the right of the author, that was there. And here in 1847 also the rights of the author, because the statute of the Anne had granted certain rights, and those were being extended to India as well. Now, here the 1957 Act, 1914 Act was replaced by the Copyright Act 57, and it has since then amended 6 times. It is 2012. Now, one thing I would like to tell you, that you see the act which we have, Trademarks Act, it was also being amended in 2010. All we have looked into, because the Paris Convention, working of the patent are the compulsory license. They are compulsory license is a part of the TRIPS agreement. Working of the patent it does not talk about at all, but the working of the patent is talked about in the Paris Convention. That is a ground for issuing the compulsory license. So, we have looked into, since we are parties, we have looked into all the flexibilities under all these different conventions to which we are the parties, and we have utilized to a fullest extent in our own laws. We have given shape to them. Though our you see laws, they are being criticized, it is being said that India is not having any viable IP policy, but I think India has its own obligations to meet, and which we are trying to meet through these particular convention, these acts, and we nobody can challenge actually. If they are so much aggrieved, they should challenge India's laws or bring a case before the WTO. Nobody has brought NATCO case or these other cases they have come up, but nobody has challenged it before the WTO. So, what laws we are having at the moment? We are having Copyright, Trademarks Act, we have the Patents Act, Semiconductor Integrated Circuits, Geographical Indications, Designs Act, Protection Plant Varieties, and of course, the Biological Diversity Act I need not to, because it is not directly on the protection of the IP, but it has IP provisions. That is why I am talking. I am not talking about the Customs Act, which is relevant for the enforcement. There is a section 11 that is very important of the, as I told you, the notification has government issued in 2010, 2007, keeping in line with the international, the customs organizations guidelines. So, these are the things which we have done, and I think, thank you. Now, you can ask if you have any question. You see, when you don't ask question, there are two reasons. Either you have not understood anything, or you have understood everything. So, I don't know that what it is right now with you.
Madam, will you mind to shed some lights on the transition period between product patent and process patent? How we are handling it? How we have handled that period?
We actually, there are guidelines, there are manuals. The patent office has brought out the manual. Manual is not legally binding, but for the examination purposes it is useful. That is how it is. You see, if you look into the manuals, it is last is 2013 March. So, they say that it is not legally, these are the guidelines for the examiners. And this is, and most of the time they are looking into the case law, like in the case of compulsory license, like in the case of 3D. They have gone into the Madras High Court judgment and the Supreme Court judgment, which was rendered in 2013. So, all these things they are taking, and then so far as software patents are concerned, they are looking into the European Patent Treaty, the convention, and they accordingly, that is article 52 of their that per EPC, that is the according to that they are giving the interpretation also, and they are looking into the case law of the United States as well. So, the transition, it is not the product patent you cannot refuse, but the process patent you can still grant.
No, after 2005, we are bound to give patents for the both 2000 for all the product patent as well as process.
Yeah, that is what I am saying.
But all those products that has been filed during this transition period.
Oh, transition period.
94
Yeah, that is actually, that is section 11A of the Patent Act is important. That is those people who have already started, because they were in the pipeline. Those people who have already started the manufacturing, they will not be touched. I mean, if they have substantial, they have made the substantial investment without defining what is substantial, they will be entitled to royalty. What will be the amount of royalty, that is also not defined, but this is it under section 11A, that they will not be, I mean, this will not be considered to be as infringement of that particular patent of that particular entrepreneur that which has filed this during transition period the patent application. That is how it is.
Just concluding remarks on this lecture, like that one convention happened, the Paris Convention happened, and the conclusion was like there should be intellectual property rights, but nothing was mentioned that how it will be formulated. After that,
They did not define. They did not define, particularly the Paris Convention did not define each right. It is for the country government, what constitute invention, what constitute inventive step, and you see all these things were left to the country concerned. If you look into our own 1970 definition of the invention and the 2005 definition of invention, they are different. So, that was left to the country concerned. Now, our definition in 2002 which we introduced, that is in accordance with the TRIPS, that is in accordance with the TRIPS. But earlier you see we were free. So, we were following the British all the substance and all those things, the mechanical apparatus. This is definition if we look into, that is there. So, countries were free in that particular sense.
after the TRIPS, that WTO came into picture.
It is a part of the WTO. TRIPS is a part. It is a multilateral agreement under the WTO, which is part and parcel. It is 1A, that is multilateral. Yeah, annexure 1A, 1B I think, 1B.
What happened to WIPO?
WIPO is there. WIPO is independent United Nations agency, specialized agency. WIPO or WIPO?
WIPO.
It is World Intellectual Property Organization. No, he is right also. French people and all this call it WIPO. So, yeah, it is independent. Yeah, they are independent. It has nothing to do with that. WIPO is governing, as I said, it is governing 26 treaties, IP treaties, including the WIPO treaty, which means the 25 other treaties it is governing. But all, as a general statement I made, in all these treaties which is governed by the WIPO, they are permissive in nature. TRIPS is not a part of the WIPO, it is a part of the WTO. It is not under the purview of the WIPO. Right. Yeah.
TRIPS is not the part of the WIPO.
Yeah.
But otherwise, WIPO is administering the another 25 treaties.
Yeah.
Different.
Different treaties on different areas, as I told you. The Paris Convention, Bern Convention, Madrid System, Madrid Protocol, Rome Convention, the Washington Treaty, Nice Convention, this is Budapest Treaty. There are number WPPT, WCT, all these treaties they are there. Okay.
And one question.
Yes, please.
Our state has, suppose India has rectified one of the international treaties, and our law has not been amended according to it. What the court will take view of it? If there is basically the breach of that.
Actually, I am talking in general, not the IP treaty. In general, if we have ratified and we have not legislated, courts will not be bound by it. This treaty will have the persuasive value in interpretation if any issue comes, but it will not, you cannot invoke that treaty to bring a case before the court unless it is legislated. Okay?
This is the legal language. That
Thank you so much.